Hello, my name is Edward Farrell. I'm an attorney at Cummins & White, LLP. Today I will be giving a short PowerPoint presentation on the basics of design professional liens in California under Civil Code Section 8300 through 8319. Quick introduction of who I am and who we are here at Cummins & White. We're a full-service law firm for over 60 years here in Newport Beach, California. Many of our clients are small to mid-sized companies. And our largest number of clients are in the construction industry, where we primarily represent design professionals, subcontractors, and material suppliers for all kinds of works of improvement. And my practice group in construction litigation and trial work specifically helps the construction industry in all matters of disputes, whether it be non-payment or allegations of untimely work. So today, I'm going to be just explaining to you the statutory guidelines in California for the design professional liens, who qualifies for them, who's considered a design professional under the code, how these liens are enforced and recorded against the property, and what information is required in these liens. Hopefully, the information I provide will help keep design professionals from falling into common pitfalls in trying to enforce these liens when they're not being paid for providing work to landowners. So really the first thing we need to figure out is who's entitled to prepare and enforce a design professional lien. Well, design professionals are specifically enumerated under Civil Code Section 8014. They only include architects, engineers, and surveyors. Now, these individuals must be licensed in their specialty, and that's important because also general contractors, even though participating in the design process, are not design professionals entitled to protection under the statute. Really, all we're looking at is those three identified professionals as being able to entitle themselves to the design professional lien. So once a design professional knows and has an understanding that he's entitled to the lien, what are the special protections afforded to him under the statute? So there's the statutory law is specifically to allow these design professionals to secure payment on projects, and specifically the private works of improvement. These are not public works. There's other mechanisms to enforce payment there, but specifically on private works of improvement. Now, the question also often arises, why do design professionals require special statutory protections? And that's because usually design professionals are performing work on a project before physical work of construction has commenced. Really, we're talking about the design process. We're talking about putting together plans, bid work, anything before actual boots are on the ground or any actual shovel work is being done. Design professional liens, really what we're talking about is the lien on the property in which the improvement is done for the recovery of fees that have been unpaid prior to the commencement of the work. And it's only permitted if a building permit or a government approval has been given for the work of improvement in which the design professional provided service. So it has to be a project that has been permitted or approved by a government agency, but that has not had the actual commencement of physical work yet. Now, design professional liens have very specific conditional enforcements that need to be adhered to make sure that they are able to effectuate payment. First, the design professional must have contracted for the work with the owner of the property to be lien. There must be a direct written contract. And it's unavailable where the project is a single-family owner-occupied residence involving construction costs of less than $100,000. However, even if the design professional lien statutes are not available, The claimant still has remedies at law, which means that they could still bring claims for breach of contract and quantum merit against a homeowner when services have been provided which improve the property in which the design professional has not been paid. When we're talking about some of the differences that a design professional lien allows, one of the things is that a preliminary notice is not required. So unlike mechanics liens, design professional liens do not require a preliminary notice to the owner prior to recording. That's because the design professional is expected to already have a contract with the owner to effectuate the lien remedy. However, not less than 10 days prior to recording the lien, a payment demand must be made. So the design professional must be demanding payment from the owner just prior to recording the lien. Once the lien is ready for recording, there must be other things that must be in place. First, as we mentioned earlier, the work of improvement must not have commenced on the property. The landowner must obviously be in default on payment to the design professional or refuse to pay upon demand. And that the amount of the claim, the amount of money that is claimed unpaid in the lien cannot exceed the lesser of the fee for services rendered under the contract or the reasonable value of the services provided. The lien also must have certain information listed in it to be proper. Obviously, the name of the design professional who's the claimant, the amount of the claim according to the parameters as mentioned in the last slide, the owner of record, the property's legal description, and an identification of the building permit or other government approval for the project must all be listed in the lien. Once the lien has the proper information and the conditions for enforcement are met, there are certain deadlines that must be met. The most important is that it must be recorded within 90 days after the design professional knows or has reason to know that the work of improvement will not commence. And then, of course, once the lien is recorded, the design professional has 90 days after recording to file a civil complaint to foreclose on the lien. The 90 days is a tight deadline and it cannot be dismissed because then the lien will expire if the lawsuit's not filed and the design professional still is not paid. The design professional lien also expires if work commences on the project. That obviously brings up the problem of what happens if the design professional lien expires because work has commenced. In that situation, the design professional may convert his recorded lien to a mechanics lien if he remains fully or partially unpaid. That's pursuant to Civil Code Section 8319. Of course, if the landowner fully or partially satisfies the lien by paying the design professional must execute and record a document evidencing the partial or full satisfaction and release of the lien. That's to make sure that there's no impermissible cloud on title if the landowner is actually paying off part of the indebtedness under the lien. So as we talk about what the takeaway is from this short presentation, it's that design professional liens are a very effective statutory remedy for a certain class of individuals involved in the construction industry. If design professionals are unpaid and they meet the conditions of enforcement and properly record the liens with the required information in the correct timeline, they have a very effective and strong argument to payment from a landowner. I hope you enjoyed this quick presentation. If you have any questions or concerns regarding design professional liens or any other construction issues or disputes, please feel free to contact me. Thank you.